what seemed to me a stupendous accomplishment of being elected as the chair of the Bar Council of England and Wales. I shared with her how this year was the first year that many women lawyers felt invested with the outcome of the elections in the Delhi High Court Bar Association, since several posts were reserved for women candidates. The credit for that goes to our Honorable Supreme Court and Justice Suryakant, who was part of the bench that passed the order. Resultantly, we now have 4 women in the Executive Committee at the Delhi High Court Bar Association. Thank you to our honorable judges for again giving us women lawyers space to shine and showcase our potential. Hopefully, in a few years to come, we can boast of having a woman lawyer as a president of the Bar Council and the Delhi High Court Bar Association. Moving on to our focus for today, is the challenges and future of family law in India and England. Family law is a broad legal domain and covers not only matrimonial rights, but also brings within its fold parental duties, inheritance right, adoption and surrogacy, child custody, interpretation of customary religious practices, to name a few. The importance of family law was beautifully expressed by Barbara in her inaugural address as chair, where she highlighted the importance of family courts that hear cases dealing with all aspects of human existence. They attempt to bring order to chaotic lives. The family courts are, it could be said, the courts of life itself, touching us all. Keeping that spirit in mind, the Delhi Family Lawyers Association, one of the 2 associations hosting this seminar, was conceived in order to recognize the dynamism of family law practice and bring together practitioners in this field who are passionate in resolving family disputes. In my opinion, family law is a nuanced field and requires a unique skill set that is not given enough respect and admiration. When appearing in family disputes, I have, apart from advocating for my clients' interests, often played the role of mediator, conciliator, counselor, and therapist. The fact that on a given day, each family court in Delhi has a cause list of approximately 60 matters underlies the importance and role of a family lawyer. Today, we have specialist lawyer associations for arbitration, insolvency, company law, competition, to name a few. The time was ripe for a family bar association, and 3 years back, the Delhi Family Lawyers Association was established. Our presidents, Senior Advocate Sunil Mittal, K.C. Jain, Malvika Rajkotia ma'am, Senior Advocate Pinky Anand, Senior Advocate Geeta Luthra, Prashant Mendirata sir, Prabjit Johar sir, Senior Advocate Nandita Rao, Prasenjit Banerjee, Seema Seth, Shreya Singhal, and myself collectively established DEFLA. While DEFLA has had several online seminars, this is our first in-person seminar, and we could not have asked for a better beginning. Before introducing our eminent speakers, I will request Kritika Gupta to introduce the Delhi High Court Women Lawyers Forum, who have collaborated with DEFLA to host this evening. Thank you.
Good evening, all. The Delhi High Court Women Lawyers Forum started 5 years back during the COVID-19 pandemic as a way to stay in touch and help each other through those difficult times. But over the 5 years, the Delhi High Court Women Lawyers Forum has grown to be a camaraderie of over 700 women who, and we are unique in the sense we do not have any elected body, we do not have a president or a secretary. The forum completely works on the principles of volunteering for organizing academic and social activities. The forum has been a friend, guide, and a mentor to so many of us in giving us job references, in helping us get briefs, and a patient ear for hearing our professional and personal angst. But most importantly, the forum has been a mentorship program for so many of us. So we hope to get the continued support of the bar and bench in our future activities. Moving on, I'd like to now invite Ms. Priya Hingorani, distinguished senior advocate, mediator, and family law expert to address us all. She has been the first women secretary of the SCBA in 50 years, and we are so grateful for her kind presence today. Priya, ma'am.
Thank you, Kritika. Honorable Justice Suryakant, Judge Supreme Court of India, the chief guest for today, Barbara Mills, KC, Chairperson of the Bar Council of England and Wales, the fifth lady to take over as on this mantle. Heartiest congratulations. Barbara is not only the chairperson, she's a mediator, she's a family law expert, apart from the different hats that she wears. And she's also a Pegasus scholar, which is very close to her heart, as we have an exchange program with the Pegasus Trust in UK and India, where we invite scholars to come over and attend and see the jurisdictional work in our courts. A very warm welcome to all of you, honorable judges, and most of the honorable judges who are here have at one point or the other heard the matrimonial matters which reach their court, and the kind of sensitivity they have expressed and shown in such cases really takes forward the fact that family law in India is evolving really to a great extent thanks to the courts. We have had a very good experience since the Family Court Act was established, and I must mention that the Family Court Act came into existence in 1984, but in 1968, the movement of women lawyers, women activists, different organizations started on asking why should we not have a family court law or a Family Court Act. And in 1982, the first draft of the Family Court Act was prepared, and I must say with great happiness that my mother, Mrs. Kapila Hingorani, had actually drafted the first legislation, which was then shared with the ministry, and ultimately in 1984, the Family Court Act came into being. Though, of course, not as they had envisaged at that point in time, but it has evolved over the years. In India, of course, under the leadership of Justice Suryakant, we've had the Mediation for the Nation campaign, which started on 1st of July 25 and concluded on 30th September. And I'm told from our friends who are mediators and who are lawyers in different parts in the court in India, in Delhi and other parts, that more than 1 lakh cases have got resolved across the country through mediation, through this drive, which is a great achievement, the kind of burden, and there are of course ancillary proceedings which do get concluded after that. So it's a huge step, an initiative which was taken by Justice Suryakant as the executive chairman of NALSA. My experience as a family court lawyer in India and with just particular jurisdiction with UK has been that while we look at matters being settled as a one-time settlement, in UK, they look at things being settled in piecemeals. If you have a no-fault divorce and you're through with the divorce, maintenance, custody issues follow, and there's no question of going back on it. And I think that's very unique for most of the Commonwealth countries, whether it is UK and Australia, and I think we'll hear more about it from Barbara in her talk. With these words, I would just like to say thank you so very much. It's a great beginning. We have one of the finest family court lawyers sitting in the audience, and we have youngsters who are wanting to do family court matters. So we look forward to them taking over from us. Most of us are now reached that senior position, and wish all of you the very best. And before I close, I must thank the committee which has put this program together, led by Mrinalini Sen, Kritika Gupta, Gayatri Virmani, Shreya Singhal, Rohini Arora, and Prasenjit Sen, who's here with us. So this committee has worked very hard in the last few weeks to put this program together, and a round of applause for them. Thank you very much.
A measured, calm voice of reason in the most stormy of cases. Miss Barbara Mills is a British barrister and a family practitioner specializing in difficult, complex, and sensitive cases concerning children. Her practice involves high conflict cases featuring allegations of serious abuse and parental alienation. Miss Mills is the first elected woman of color holding the position of the chair of the Bar Council of England and Wales in its 131 years history. Ma'am was called to the bar in 1990 and took silk in 2020. King's Counsel Barbara Mills is also an accredited and experienced family mediator, arbitrator, and collaboratively trained counsel who has a gilt-edged expertise in mediation and arbitration. Some of her notable mediations include a dispute between two internationally acclaimed musicians and another where she assisted a foreign royal couple to reach resolution over the arrangements for their children across two countries. Ma'am is regularly instructed by local authorities and guardians in complex care proceedings and also offers early neutral evaluation. Recipient of the 2024 Lifetime Achievement Award for Women and Diversity in Law, Ma'am is a powerful and compelling, one-of-a-kind advocate who is often described as tenacious, strategic, and laser-sharp. Ms. Mills is incredible, and we are so pleased to have you here today, ma'am. I now call upon King's Counsel Barbara Mills to deliver the keynote address.
Lots of microphones here to grapple with. Good evening. A real pleasure to be with you today. Let me make sure that I am ready. First of all, thanks to the Honourable Justice Surikant, the High Court judges who are present here today, the other presidents, the family court judges, thank you, the President of the Delhi High Court Bar Association, the Executive Committee, senior advocates and colleagues. It is a real pleasure to be with you this evening. Thank you for the invitation. Thank you to all of you for being here. It's one thing to be invited, but to speak to an empty room would have been quite something, so I'm glad to see you all. Over the last 20 years, the Bar Council of England and Wales has had a strong connection to Indian lawyers. To begin with, that great relationship was founded on knowledge sharing, advocacy training, seminars and conferences. And latterly, our focus has been more about the liberalization of your market to compare to ours. The conversations over the years have focused on commercial law and the rule of law. As you heard, the Bar Council of England and Wales has not had a specialist family barrister as its chair since 1988. So one of my priorities this year is to raise the voice of family law whenever and wherever I can, because unlike what those who don't practice family law think, we're not in fact a second-class citizen when it comes to laws. Ours is a complex, very difficult area, and it's very great to be in a room with all of you. The systems that we have in England and India are different, but people are people wherever they are. And when their families break down, the issues seem to be very similar. The challenges we face, therefore, are the same, from access to justice, lack of funding to pursue claims, unacceptable delays to the system, which we know is inimical to the welfare of children and their families. And as the diaspora grows, both here and in England, that array of domestic issues are overlaid by cross-border challenges. So how should family law evolve to reflect the realities of modern families? What, for example, might family law look like in 2075, 50 years' time? Well, to begin my thoughts, I went to a speech given by Lord Justice Peter Jackson, one of the people who trained me, who now sits in the Court of Appeal in England. And the words he ended this speech with I think is a useful place for us to begin to think about what family law could look like in the future. He said this: "I'll end on a flight of fancy. In describing family law as having reached a state of maturity, my vision is not that it should carry on aging like the rest of us until it becomes senile. Family law has already experienced its old age in past centuries with their narrow growth and range of concerns. We need to learn from the wisdom of years, embodied in great practitioners and judges of the past who were no less well-intentioned than we are today. But looking to the future," he said, "we should not be telling family law to grow up and behave like everyone else. Rather, we should be encouraging it to become simpler, more flexible, more open to new ideas and experiences. In fact, he said, to become younger. So how can we make that happen? Well, when you get stuck, the youngsters tell us to go to AI. So I put all of that information into ChatGPT and said, what does the future of family law look like? So I put in the substantive issues, the processes. Within seconds, as AI does, it came back with the family law in 2075, exclamation marks everywhere. It said this: a scene is a sleek, holographic mediation room with floating digital screens. AI mediator says, welcome. Today's dispute involves the Smiths over custody battles and custody arrangements. Mr. Smith says, she wants to move to Mars. What about our kids? Miss Smith says, it's got better opportunities, plus they have zero gravity playtime. The AI mediator said, let's explore the options. How about a virtual family vacation to Mars? Could you live with that? Hologram project the Martian landscapes, kids giggling in zero gravity. Mediator says, option 1, mediation for flexibility. Option 2, courts. Judges have zero patience. Mr. Smith said, what about arbitration? The mediator said, decide quickly, my battery is running low. They all nod and realize that mediation is the best bet. Do you notice there are no lawyers in that picture? Court is disregarded, and the mediator is best. So as I talked to you about the future of family law, how do we stop that AI reality from becoming our reality? I think to be simpler, we need 3 things. First, we need to better use the dispute resolution fora that we already have, and we do that by understanding what they are. We need to understand it, and our clients need to understand it, so that their first thought isn't, I am getting divorced, the only place to go is court. We need to tell them about those differences. And historically, family law in England and in India has been characterized by the adversarial setting, proceedings, lengthy court battles, and outcomes that often left families fractured and feeling fractured. The system, while rooted in the principles of justice, frequently failed to prioritize the emotional well-being of those involved. I find that in England and Wales, lawyers often don't understand the options. Then the options range from mediation, as you have it here, which is one of the best known options, conciliation, collaborative law, which is, I think, a burgeoning area in India. That's all on one side. And in England and Wales, we also have arbitration. Arbitration, as you know, is a form of dispute resolution which takes place outside the formal courtroom. We don't use it to dissolve the marriage itself, but in England and Wales, we can and do use arbitration to, if the case is suitable for it, to adjudicate a dispute concerning either the finances or the child custody arrangements of parties when they are separating or divorcing. They agree the bounds of the scope, they agree the arbitrator, and the arbitrator's decision, if it's in finances, is called an award, and if it's in children, it's called a determination. We have been arbitrating financial cases since 2012, and children cases since 2016. And the scope, and as I've been talking to colleagues here, I know that you don't use arbitration and don't think you ought to use arbitration, but I'll tell you a little bit about the scope as we use arbitration, in particular in relation to children. And generally, any issue between parents or other persons holding parental responsibility can come into arbitration. So where the child should live, where they go to school, visiting arrangements, their education, disputes concerning routine. We can use it to decide where they live within the country, and we can decide it to live if they're relocating out of the country. And the benefits of arbitration are obvious, aren't they? You have the choice of an arbitrator, the choice of venue, the date and time. I was at your Court Annex Mediation Centre here at the Delhi High Court today, and I can see there that there is that blend between the court and mediation working very well. And I know, as I said to the people who run it, that we have much to learn from your model there. But I think that the first thing we need to understand are the choices that we have. The second, I think, if we're to keep hold of family lawyers, is to be bold as to the choices. So in England and Wales, I was very pleased to hear today that here you're able to use mediation even if there's domestic abuse and domestic violence, something that is absolutely frowned upon in England and Wales, because we take the view that if there's any kind of risk to a parent or a child, you shouldn't use mediation. We use arbitration, and you don't know that you ought to use arbitration. So I think that one of the things available to us is to stay young by being bold. And we can be bolder by increasing the scope of what we do with mediation, and perhaps you can be bolder by allowing arbitration into your cases, something that we might want to discuss one with the other in the future. I think that the final guarantee for us as family lawyers is to understand how we better look after ourselves, something that we are just beginning to talk about in England and Wales. So let me tell you a little bit about what made me go into mediation. As you heard described, mine is a high conflict area. So most people who instruct me are high-profile families who are in high conflict. Either they're not seeing their children, and all of the work I do is children, or there is an international element to it. So really hard nuts to crack. In 2002, I was instructed on behalf of a father who wanted more time with his two little girls. And when I was instructed, those two little girls were both in primary school and both doing incredibly well. And they spent time with their father every other weekend. He wanted to share their care, so they were with him 50% of the time. The mother disagreed. The case took 3 years to complete. And by the time the case completed, the children were shells of themselves. Every member of the family was in therapy, including the children. They had gone from bubbly, high-spirited, free children to nail-biters who were both wetting the bed. And the court's ultimate decision was to transfer their care from their mother to their father, who was my client. So on the face of it, we won the case. And I felt dreadful, because I felt I had been a part of the devastation of this family, who were never really going to be the same again. I trained then as a mediator when I was introduced to it. And that led me to sit as a recorder, and then as an arbitrator, and then since 2023 as a deputy High Court judge. And the more qualifications I acquired away from the day job, the more I came to see myself as a resolver of disputes and conflict, and the more I came to realize that the notion that as a family lawyer I could stay neutral in the face of my client's distress was just a falsehood. I had been in every single way emotionally and psychologically engaged with the fallout from that family. We often talk about the protection of lawyers, certainly in our jurisdiction, because they get attacked. There are physical attacks to them, there are verbal attacks to them, and I think it is time as family lawyers to do very much better at looking after our psychological health. I have learnt over the years that my well-being and those of my colleagues who sustain successful practices are not something they can do occasionally. It's something they have to do all of the time. And as chair of the Bar of England and Wales, it has been one of my priorities this year to look very carefully at the well-being. And you know, since I announced that I was interested in it, I have been blown away by how many people have shared their stories and difficulties with me. You know, take the young practitioner who said to me he had never had any mental health challenges until COVID. And in COVID, he was being led in a case where the children were alleged to have been sexually abused. He was working in a small flat. He was working at his kitchen table. He was cooking at his kitchen table, and he was trying to eat at his kitchen table. And there came a time when he could no longer cook and eat at the same place that he worked, and his mental health began to deteriorate. Or the young woman who told me only a couple of weeks ago that she has been instructed in the Southport inquiry. That's an inquiry looking into how it is that a young man had killed 3 little girls, and she had been watching the tapes of the murder scene with some police officers until she couldn't do it anymore. And she found herself in deep distress. In both of those cases, those young people were lucky enough to be surrounded by the sorts of people who spotted in them that they were in crisis. And certainly in England and Wales, we have become very used to talking about our well-being, but still, year on year, the statistics show that our mental health is not doing well. What we know is that as professionals who are exposed to vicarious trauma and distress, which is being experienced by our clients, we too suffer the same vicariously. If you add to that the relentless pressure and high expectations that the job demands, the competitiveness required and the repercussions of the adversarial system, it is little wonder that you can, from time to time, feel the stress and burnout that we can. And any other professional who deals with the sorts of subject matters that we deal with as family lawyers, all, without exception, have help. What I would like to see in the profession globally is well-being losing its stigma as a sign of weakness and to be elevated to the same non-negotiable level as you would any other business expense, whether it's your insurance or your accountant. Let me settle. And the thing about our mental health is that too often we think we're the exception, that we will do it anyway. So let me leave you with a quote that was said by Dr. Naomi Raymond. She said this: "The expectation that we can be immersed in suffering and loss daily and not be touched by it is as unrealistic as expecting to be able to walk through water without getting wet. Almost impossible." So in England and Wales, what we're doing, and I'm raising it to encourage those of you here to think about it, is reflective supervision. For those less familiar with the term, it's a reflective approach which provides space for a lawyer to analyze and evaluate their experiences, to debrief after challenging and stressful encounters, and built into your practice, which happens regularly. We have been piloting this in England and Wales with family lawyers and criminal lawyers, commercial lawyers and civil lawyers. We are going to look at the results of that, and I very much hope to announce it to the profession before I leave my role this year. So what I would say to you is that in the years ahead, the trajectory of family law will be defined not only by the tools we deploy, mediation, collaborative processes, and principled arbitration, but by the clarity with which we explain them to every family that seeks resolution. For India and England and Wales alike, a robust out-of-court ecosystem must be underpinned by accessible guidance, culturally informed practice, and rigorous standards that protect the weakest voices while preserving autonomy. It is equally essential, in my view, that to focus on the well-being of family lawyers, to ensure that we have sustainable workloads, professional training, institutional support, so that those who guide families can do so with courage, compassion, and technical excellence. If we invest in these elements together, as judges, practitioners, and policymakers, we'll unlock a system where dispute resolution is humane, efficient, trusted, and sustainable. Today's challenges demand a shared vision that non-court dispute fora, such as mediation and arbitration, are not the last resorts, but the first. Informed choices embedded in everyday practice, and cross-border learning informing local wisdom, and well-being of the professionals who steward these processes becoming standards of justice itself. Let us commit then to a future in which families find resolution with dignity and speed through mediation and principal arbitration that is understood and readily available. Let us commit too to professionals who enable these outcomes to invest in training, supervision, and reflective practice. As we chart this path, may we heed a shared reminder. The true measure, in my view, of a legal system is not how it handles the loudest disputes, but how it respects and resolves that quiet, enduring needs of families. Let's together across our jurisdictions build a future where mediation, arbitration, and the well-being of those who guide them stand at the very heart of sustainable justice. Justice endures when families are heard. Disputes are resolved with care, and those who guide the processes are themselves cared for in return. So AI might threaten us, but we have the tools and levers to remain sustainable. Thank you.
Thank you, Barbara. You've left us much to think about. And our chief guest today is Honorable Justice Suryakant, Judge of the Supreme Court. Sir graduated from Government Postgraduate College, Hisar, in 1981, and started practicing law at the District Court, Hisar, in 1984, and shifted to Chandigarh in 1985 to practice in the Punjab and Haryana High Court. Sir has specialized in constitutional service and civil matters, represented a number of universities, boards, corporations, banks, and also the High Court itself. Sir earned the distinction of being appointed the youngest Advocate General of Haryana on 7th of July 2000. Designated as Senior Advocate in March 2001, Sir held the office of the Advocate General Haryana till his elevation as a permanent judge to the Punjab and Haryana High Court in 2004. Sir has also been nominated as a member of the governing body of National Legal Services Authority for 2 consecutive terms. Presently, Sir is a member of various committees of Indian Law Institute, a deemed university under the aegis of Honorable Supreme Court of India. Sir has also earned another distinction of standing first class in his master's degree in law in 2011 from Kurukshetra University. Justice Suryakant has delivered significant family law judgments that emphasize social reality over rigid traditional interpretation. Sir's decisions consistently prioritize the welfare of women and children and reflect a modern understanding of family structures. In the matter of Apurva versus Dolly, Sir ruled that the rights of wife and children to maintenance have precedence over creditors' rights on the husband's estate. In a landmark 2025 ruling, Sir led a bench that expanded the definition of mother to include stepmothers for family pension benefits, highlighting the need for welfare schemes to reflect caregiving realities beyond biology. Another notable 2025 ruling affirmed a child's legitimacy within a marriage, even if adultery is alleged, stressing that a DNA test cannot be ordered based solely on such claims due to privacy concerns. Justice Suryakant has also demonstrated a commitment to protecting vulnerable spouses, as seen in a 2024 case where he awarded a woman permanent alimony with interest after a nearly 3-decade-long legal battle, deeming the judicial process grossly injudicious to her. These rulings demonstrate Sir's pragmatic and compassionate approach to family law, aiming to align legal outcomes with contemporary social norms and the principles of equity and justice. I request Justice Suryakant, Sir, to address our gathering.
My brother and sister judges of Delhi High Court, Ms. Barbara Mills, King's Counsel and Chairperson Bar Council of England and Wales, Ms. Priya Hingurani, Senior Advocate and the organizer of this event, Mr. Hariharan, Senior Advocate and President of the Delhi High Court Bar Association, other office bearers, Mr. Prasanajit Banerjee, Secretary Delhi Family Lawyers Association, and on the dais, senior advocates, members of the bar, judicial officers, ladies and gentlemen, friends from media, a very good evening to all of you. It gives me great pleasure to speak on a subject that, in my view, holds profound significance in the contemporary world. Before I begin, I would like to seize this opportunity to congratulate the Delhi Family Lawyers Association and the Delhi High Court Women Lawyers Forum for this commendable initiative in organizing the seminar and creating a platform for such meaningful dialogue. Family law and its practice within the Indian legal fraternity are often overlooked, and I believe unduly simplified as merely a field concerned with divorce. Family courts are too often perceived as spaces charged with emotions and tensions, and regarded as somehow less rigorous than criminal or a public law practice or even a judicial adjudicatory forum. I could not disagree more. Family law, perhaps more than any other branch of private law, exists at the intersection of emotion, morality, and justice. It governs our most intimate relationships while simultaneously reflecting our cultural ethos and constitutional values. It is indeed one of the most intricate areas of legal practice, demanding from both judges and the practitioners a nuanced understanding of human relationship, social realities, and the art of interpreting static laws to resolve interwoven familial issues and conflicts. In both England and India, the evolution of family law tells a story larger than that of marriage or inheritance. Rather, it tells the story of how societies negotiate change, how they reconcile faith with freedom, how they transform the private toward the constitutional realm. Barbara has most eloquently and comprehensively analyzed the family law framework in England and Wales and her own personal experience as a practitioner, which she has shared with us. I therefore shall endeavor to build upon her insights and focus largely on the Indian position. The historical trajectories of the family law in these two jurisdictions are distinct and slightly, and rather maybe even significantly different, yet they intersect through common principles of justice and equity. Family law in England emerged from the ecclesiastical courts that once regulated marriage, legitimacy, and morality before gradually undergoing a process of secularization culminating in the Matrimonial Causes Act and later the Children Act of 1989. In India, the evolution of family law followed a far more layered route. Prior to colonial rule, familial relations and disputes were governed by the less codified legal principles and more by the prevailing social and moral order. Unlike in many Western societies where marriage was viewed primarily as a civil contract, in early Indian tradition, it was regarded as a sacred and enduring sacrament, as we used to call a sanskar, deeply rooted in religious and philosophical thought. The Rig Veda and various other ancient texts do reflect that sanctity of the marital bond was extremely important. The questions concerning legitimacy inheritance, and succession were similarly shaped by custom, religious restraints, and long-standing social practices. The codification of personal laws for Hindus and Muslims took place during the colonial period. However, this effort, though administrative in intent, did not account for the diverse practices and deeply rooted belief systems that informed each community's understanding of family and kinship. The result was a series of legal formulations that often stood at odds with indigenous traditions. In my opinion, such an industrial effort could not have borne any fruit without truly appreciating that India is a beautiful mosaic of religions, languages, culture, and religious diversities, where each community has its own distinct way of carrying on its practices, traditions, and conversions. It was only after independence that both the Indian legislature and the judiciary undertook the enormous task of reconstructing and interpreting personal laws to reflect social reform and the constitutional vision. The result was a diverse legal framework comprising legislation such as the Hindu Marriage Act of 1955, which outlines the essential conditions of a valid Hindu marriage, or the Muslim Women Protection of Rights or Divorce Act 1986, which, following the landmark ruling in Shah Bano, recognized that a divorced Muslim woman's right to maintenance does exist. The outcome has been a plural system that blends traditional conventions with modern realities, intentionally overlaid by Constitution of India. When we talk of the marriage, divorce, the question of gender equality does arise. I therefore believe that family law as a discipline is vast and multifaceted, yet much of it continues to center on the institution of marriage and its dissolution. In both India and England, the most significant area of convergence today lies not merely in the evolving interpretation of these institutions, but in the growing recognition of gender equality as their guiding principle. Marriage, by its very nature, can be demanding for both partners, yet history reveals that across continents, cultures, and eras, it has too often been misused as an instrument of subjugation against women. While this remains an uncomfortable truth, contemporary legal and social reforms in both jurisdictions are gradually transforming marriage from a site of inequality into a pious partnership grounded in dignity, mutual respect, and constitutional values of equality. From my reading of the law, it seems to me that across the seas in England, the principle of fairness governs financial remedies after divorce. That's why in Miller versus Miller, the House of Lords not only emphasized that fairness encompasses both needs and compensation, but also recognized equality as the benchmark. Similarly, in White versus White, it was established that equality of contribution between spouses in property division, moving behind the theory of breadwinner versus homemaker, need to be overlooked. I am told that more recently, the enactment of the Divorce, Dissolution and Separation Act of 2020 has introduced the concept of no-fault divorce, putting an end to the culture of blame and emotional adversarialism. In India, the judiciary and the Indian legislature has continually taken measures, build legal framework that can safeguard the rights of women. For example, we have now Dowry Prohibition Act of 1961 from last more than now 60 years, and the Protection of Women from Domestic Violence Act 2005, which stand as landmark pieces of legislation When enforced by transformative judicial interpretation, both these statutes have yielded significant social impact. Continuing along the same pathway of reform, the Supreme Court has made significant strides by mandating the registration of marriage irrespective of religion, to keep a check on child marriages, prevent marriages without consent, check bigamy or polygamy, enable women's right to maintenance, inheritance and residence, and deter desertion and possible exploitation of the young women. Such decisive rulings have also made way for decisions such as that in Shaira Bano, where the practice of triple talaq was rendered unconstitutional. Similarly, the Supreme Court has successfully dismantled the patriarchal notions embedded in the inheritance laws to ensure true equality. Even in the realm of reproductive rights, the Supreme Court has unequivocally respected a woman's right to make reproductive choices as a dimension of personal liberty. Indian family law is thus an evolving body of jurisprudence that is empathetic without being paternalistic, principled without being rigid. However, family law is far from static. It continues to evolve in response to shifting social realities and transnational complexities. One recurring issue that frequently arises across courts in India concerns the recognition and indirect enforcement of foreign divorce decrees. This is, in my view, a challenge faced by many jurisdictions today as the world grows increasingly interconnected and spouses often reside in different countries, giving rise to cross-border matrimonial disputes. In this context, our Supreme Court has laid down comprehensive guidelines governing the recognition of foreign matrimonial judgments. However, it has also been expressly held that such judgments would not be recognized in India if they were obtained by fraud or if they contravened the principles of natural justice or the substantive laws of this country. Such cross-border marital disputes become significantly more complex when children are involved. Barbara was also referring to that difficulty being experienced in England. It becomes imperative for courts across jurisdictions in such cases to uphold the principle of comity of courts, ensuring mutual respect and cooperation in adjudication while remaining steadfast in their primary duty to protect the welfare and well-being of the child. The protection of children and the safeguarding of their welfare is a principle universally recognized across jurisdictions, and in this regard, both India and England share a largely aligned approach. In England, the Children Act of 1989 firmly enshrines the paramountcy of the child's welfare, establishing that the best interests of the child must always take precedence. The doctrine of best interest of the child has likewise been firmly entrenched by Indian courts across a wide range of family law matters and has been applied with equal rigor even in cases concerning the adoption and custody of children. I had in fact an opportunity to apply this doctrine in a case where custody of a 22-year-old son with cognitive disability was awarded to his mother, who was a US citizen. The decision was guided by the consideration that since he had been receiving state-of-the-art health care in the United States, it would be in his best interest to reside with his mother abroad. As I draw my address to a close, I am reminded of a beautiful quote and I recently came across, which I would like to share with you. It says, "Law must be a social engineer, responding to the felt necessities of the time and the silent cry of the weak." This sentiment The sentiment, namely the silent cry of the weak, captures the very essence of family law, a branch that must blossom with society yet remain deeply attuned to the human condition. Both in England and in India, family law stands as a living instrument, one that not only governs private relationships but also mirrors our collective commitment to justice, equality, and compassion. As we continue to navigate new frontiers, it becomes our shared duty as lawyers, judges, and scholars to ensure that the law remains humane, inclusive, and responsive to the changing contours of family and society. Thank you very much. Thank you for giving me this opportunity to share my views.
Thank you so much, sir, for your insightful words. And we have an excited audience who would like to ask some questions. We are open now for any questions if the audience would like to ask. Let's give the backbencher a chance. I see a hand raised there. We'll get to him a mic. My colleague Shreya is there with the mic. Thank you. Would you like to come forward to ask your question? We can
Sure.
come. Yeah.
My question is to Ms. Mills. Ms. Mills, you mentioned that you can't run on water without getting wet. Now, if you apply the same theory to AI, AI can simulate empathy to a certain extent. It cannot put itself in the shoes of the people whom it's supposed to be mediating. A mediator is required because of that human connection that it brings. How do you think mediation is going to be impacted if AI is used and human connection is taken out? Because at the end of the day, if you believe that AI is as powered as it is now, it still can't give you the most optimal solution based on what will actually happen, considering the emotions involved in the process. So what is your opinion on it?
I was trying to make the point that AI is not going to replace us anytime soon. I was trying to reassure you it won't replace us anytime soon. Look, I don't think AI, with all of its incredible powers and the speed with which it told me that answer that I shared with you, can do what mediators do. You have to hold the room as a human being. You have to be able to read the room as a human being. You have to be able to hold on to the conflict as a human being. AI is nowhere near doing that. I mean, we have to respect AI. It's coming, for sure, but it's not going to replace us anytime soon. Shall I stay here or go?
Is there any other question from the audience? Prashant, sir.
Hi, my question is to Ms. Mills. In fact, I'm going to be greedy. I'll have two questions. The first one, is it compulsory to have pre-litigation mediation in matrimonial matters back home there in Wales and UK? Yes?
So last year there was a case that the Bar Council actually intervened in to say something in it, where the court now can ask people to leave the court process and mediate, just like you do here, the court annex stuff.
No, pre-litigation.
Yes, so I'm coming to that. So yes. Pre-litigation, we have a system which has, as part of its form, that you have to go to what's called an information and assessment meeting. And you have to go to that before you issue proceedings. But it has a number of exceptions, and people are people, right? So when they're in the height of conflict, and we have to educate people to realize that divorce and permanent separation doesn't have to be painful, it doesn't have to be expensive, it doesn't have to be all the things that court offers. So a lot of the time, people will say, oh, it's really urgent, so I can't mediate. He's being violent, I can't mediate. And as long as the court doesn't push back and allow them to make the application, then proceed, then the system fails. So yes, in theory we have it, but there are always exceptions that people try and get around.
Thank you. And second question, I said I was going to be greedy. That's with regard to, see, we have two issues that the problem, what ails here. One is the litigation tends to go for much longer period, and we want to finish it off sooner. The only difficulty that we face is we are not able to come to a maintenance issue, the orders on maintenance. And the other is with regard to the parental alienation. are the courts in UK and Wales referring matters to child psychologists and psychiatrists to make sure that the parental alienation is reduced? Because there is a lot of parental alienation happening in contested litigations here in India.
So one of the bars to mediating in England and Wales is that if there is any risk to a child or one of the parents, then mediation is ruled out. So if there are any safeguarding issues, mediation is ruled out. And on the basis that alienation is a form of abuse of a child, it would be ruled out. And of course, when you're going into mediation, one of the things you have to be careful of is that the balance of power is held by the mediator, and often with alienation there's a skewed. So the short answer is, if there's alienation, it isn't fit for mediation and the court doesn't encourage it. The other thing is that there was a case, I happen to have been involved in that case, and in that case the court said that alienation was not something that a psychologist could find, it was a question of fact. So there's no such thing as parental alienation, they're alienating behaviors. So a judge has to hear the evidence. Often she says he was violent, he says you're alienating. The court has to decide, is she right about the violence or is he right about the alienation? So it's a question of fact, and when that's determined, you can carry on with the rest of the case.
Thank you so much.
No
Thank
problem.
you.
Sorry,
For
we're
me?
out of time.
Oh, we're out of time.
Yeah, so
You can ask us separately over tea. I think we're out of time. Please go ahead.
So my question is to Sir Suryakant sir. So there is a matter, we got a divorce for my client, and that was reported also on irretrievable breakdown of marriage, Manish versus Sandhya. I was the counsel for husband in that case. Sir, after some time, when the lady challenged that matter in the Supreme Court, I appeared before the court, and court asked me that this will not be, we will gonna set aside because this is a ground which is not in the Hindu Marriage Act as of now, and just go back and talk to your client for giving a alimony to the woman. So my question is, sir, if it is not a ground, but in High Court we have received this and it got reported also. But when we went to the Supreme Court, it was again a challenge for us to prove this irretrievable breakdown. So I wanted to catch the situation and wanted to ask the question.
My suggestion is that I will answer this question through some judgment.
It's my honor today to give a vote of thanks as well as closing remarks for the seminar today. It gives me great pride to say that the Delhi Family Lawyers Association has finally had this opportunity to have its first seminar in person, and I would say that it has been a grand success. Albeit a small step, I think with the nature of attendance and the kind of content we had today, it gives me great pride that it's been a big success. I would like, on behalf of the organizers, which is Delhi Family Lawyers Association and Delhi High Court Women Lawyers Forum, I want to profusely thank both Honorable Mr. Justice Suryakant, Judge, Supreme Court of India, and our chief guest today, and Ms. Barbara Mills, King's Counsel, Chair, Bar Council, England and Wales, and our keynote speaker today, for sharing their erudite thoughts on cross-cultural perspectives, emerging trends, and challenges in family law in England and India. I congratulate Ms. Mrinalini Sen and Ms. Kritika Gupta for so skillfully and adroitly moderating today's seminar. I would take this opportunity to connect through my personal experience what would be the nature of the thoughts shared by our erudite speakers today. While appearing in a matter which before my Lord Justice Suryakant, it was called the Rolls-Royce matter. And in that, both the counsels were fiercely arguing the matters, as usual in family law matters. I was appearing for the respondent, and Ms. Vibha Dutt Makhija, if your lordship remembers, was appearing for the petitioner. And we were locked horns and arguing very vociferously when my Lord Justice Suryakant said that in these matters, even if the stakes are high, it is best advisable to try to settle the matters, or else the court knows how to deal with the rights in issues. Both of us got the broad hint, and every lawyer knows that there are weaknesses to his or her case while arguing, even in the best of causes. And both of us got together, and eventually, even in that very, very fraught and highly disputed, contentious matter, settlement was arrived. And I remember at the end, my Lord Justice Suryakant, while closing the matter, said, "I am happy that good sense prevailed." So good sense is very important, and taking a cue from that, I have noted that the honorable guest here and Ms. Barbara Mills, the King's Counsel, extremely erudite and a passionate espousal of family law jurisprudence in England and Wales, is something which is a beacon for us Indian lawyers here, Delhi lawyers especially, for us to follow and make family law as pivotal jurisprudence as possible in India, so that it progresses and evolves in that manner. Of course, one of the most important things which I've noted is her very deep connection with mediation and even arbitration. Of course, arbitration is something which is not yet something which is pursued in India for family law, but insofar as mediation is concerned, it is a big thing in India. And in fact, my Lord Justice Suryakant, with his mediation drive, with a tremendous success it has achieved, I would say that's a deep connect between India and England in that regard. I would also take this opportunity, in fact, I'm honored to deliver this vote of thanks. I would express my sincere gratitude to all the honorable High Court judges, Delhi High Court judges who have congregated here today. I realize it is not easy for them to have left their very busy schedule and joined us today. I am deeply grateful for them to have shared their time with us. And your participation and engagement have made this event a truly memorable one, I must say. Insofar as my closing, and I want to thank each one of you who has come today, for all the great family law bar which I belong to, and which all of us belong to. I'm deeply grateful. I'm sure that we are going to go from strength to strength, all of us. As closing remarks, I would very briefly put it. India and England, we share, of course, a very, very interesting 200-year past. Of course, it's a colonial one. However, the most important thing is that to a large extent, we have inherited a judicial system, a legal system from England, and then we have not only evolved it and made it, we have in a sense indigenized it and made it a very a unique thing for India itself. But the legal perspective in this intermingling perspective makes it even more interesting, bringing forth new narratives which throw up legal challenges in commercial, constitutional, and especially family perspective. Both the legal systems need to learn from each other and lean upon each other from each other's legal experiences. Family law, which embodies, as my Lord Justice Suryakant correctly put, social and gender justice in its core. It is a vital area of legal practice, family law, and in this regard, a good indicator of the way the two cultures and national perspectives are engaging with each other. In the absence of Hague, this becomes even more important, because this mutual understanding and connection is very important to deal with the diaspora which Ms. Mills was indicating, and the Indian legal system to engage. Otherwise, there will be a possibility of legal judicial orders remaining unimplemented or not being followed, and for that matter, comity is very important in issues of parental abduction, even matters relating to maintenance and alimony if they have a cross-border connection. Keeping this in mind, I would now close this entire seminar and would request all of you to join us for high tea. Sorry, in the meantime, we have to give the mementos. That's true. I'm so sorry.
May I request the President of the Bar, Mr. Hariharan, to kindly come and present a memento to Honorable Justice Suryakant, the Chief Guest for today. May I request Ms. Nandita Rao, Senior Advocate, and one of the founders of the Delhi Women Lawyers Forum during COVID times, to present a memento to Barbara Mills. And Defla, of course. May I request... No, just give it in a minute. 1 minute. Just give it. Okay. May I now request everybody to join us for high tea. Thank you very much.